Welcome to another deep dive. Looks like we're tackling robbery and related offenses in Canada today.
Always a fascinating area.
You bet. And we've got some serious legal documents to work with, too. Our mission: to break it all down, make sense of the jargon, and maybe uncover some surprises along the way.
Sounds like a plan.
All right, let's jump right in. Now, when you hear the word robbery, you might picture like a classic bank heist scene, right? Masks, guns, bags of money.
Hollywood definitely loves that imagery.
But in reality, robbery in Canada is way more nuanced than that. Turns out there are actually 4 distinct ways you can commit robbery, all outlined in Section 343 of the Criminal Code.
Yes, the criminal code. Always a good place to start.
So we've got stealing while using violence or threats of violence. Seems pretty straightforward.
On the surface, yes.
Then there's stealing and then using violence, like you grab the goods and then shove someone out of the way as you make your escape. And that violence can happen right before, during, or even after the actual theft.
It's all about the timing and the connection between the theft and the violence.
Okay, then it gets even trickier. We've got assault with the intent to steal.
Now we're getting into the realm of intent, which can be a slippery slope in court.
Absolutely. And finally, we have stealing while armed with a weapon. And guess what? A fake weapon counts.
The threat of violence, real or perceived, is still a major factor in these cases.
Okay, so 4 ways to commit robbery. Got it. But here's where things get really interesting. You ready for this?
Hit me with it.
You don't even have to actually steal anything to be charged with robbery.
Wait, what? How's that possible?
I know, right? Mind blown. It all comes down to that assault with intent to steal thing, Section 343C. So even if the robbery is unsuccessful, if you assault someone with the clear intention of stealing from them, bam, robbery charge.
So, like, if someone tries to pickpocket me but I catch them before they grab my wallet, they could still be in serious trouble.
You got it. The assault, combined with the intent to steal, is enough to meet the definition of robbery under Canadian law. Crazy, huh?
Definitely makes you think twice about even attempting something like that.
For sure. Okay, let's say we're reading through these legal documents, and we keep seeing the word violence pop up. We might picture, like, a brutal attack, someone getting seriously hurt.
Yeah, that's the image that usually comes to mind.
But based on the cases you've seen, violence, in the legal sense, can be a lot more subtle than that, right?
Absolutely. We need to expand our understanding of what violence actually means in a robbery case. It's not always about black eyes and broken bones.
There was even one case where simply holding a victim's arms down to overcome resistance was considered enough to qualify as violence.
It might seem minor, but it goes back to that concept of force and the violation of personal autonomy. Even minimal force can have some pretty serious legal implications.
Makes sense. You're taking away someone's control over their own body, and that's a big deal.
Okay, let's talk weapons. Section 343 tells us that robbery committed while armed comes with its own set of challenges. And here's the kicker. Even pretending to have a weapon can get you into hot water. That's right. The threat alone is enough to instill fear and potentially escalate the situation.
But there are limits, right? We saw in these documents that just pretending to have a weapon in your fist isn't going to cut it. There has to be something more,
Yeah.
right? Like, you have to really sell it.
The courts have definitely set some parameters. A simple clenched fist, probably not enough. But if you're, say, pointing your finger under your jacket and threatening to shoot, that's a different story. It's about whether a reasonable person would believe you actually have a weapon based on your actions and words.
Okay, that makes sense. So what about the definition of an offensive weapon? Is it as straightforward as it sounds, or is it more nuanced than that?
Way more nuanced. The criminal code takes a super broad approach when defining offensive weapon. It's not just about guns and knives. We're talking about any object that's used, designed to be used, or even intended to be used to cause harm or intimidate.
So like a baseball bat or a crowbar or even a heavy rock could all be considered offensive weapons depending on the context.
Exactly. It all comes down to how the object is used and the intent behind that use. A baseball bat used for its intended purpose on a baseball field, not a weapon. But that same bat used to threaten someone during a robbery. Definitely a weapon.
Okay, that's starting to make a lot more sense. Now, it looks like you're really interested in the defenses that might be used in a robbery case based on the legal documents you sent over. It's understandable everyone deserves a fair shot in court, and it seems like most defense strategies tend to focus on one of 3 things: the actual theft, the alleged assault, or the connection between the two.
You've hit the nail on the head. Those are the 3 key areas where defense attorneys often concentrate their efforts.
So if no theft actually occurred, or if the accused argues they had a legal right to the property, that could be a real game changer.
It could be. If there's no theft, the whole foundation of the robbery charge crumbles. And if the accused can demonstrate they had a legitimate claim to the property, well, that's a strong argument in their favor.
I'm guessing proving intent, or lack thereof, is huge in these cases.
Absolutely. Intent is often the trickiest thing to prove. It's not just about what happened, but why it happened.
Let's say someone breaks into a car and takes a laptop. If they claim they thought the car belonged to a friend and they were just borrowing the laptop, could that work as a defense?
It's possible, but it would depend on how convincingly they could argue that their belief was genuine. The Crown has to prove beyond a reasonable doubt that they had the intent to permanently deprive the owner of their property.
Fascinating. It really highlights the importance of a strong defense strategy. So we've got defenses related to the theft itself. What about challenging the assault? What are some common approaches there?
Those often mirror the defenses used in regular assault cases. Things like provocation or consent come into play.
So if someone claims they were acting in self-defense during a robbery, that could potentially be a valid defense.
Exactly. If they can convince the court that they were genuinely defending themselves, it could make all the difference. It often comes down to the evidence and the credibility of the witnesses.
I bet those cases get pretty complex. Okay, last but not least, let's tackle the connection between the theft and the assault. Can someone actually argue that those were two separate, unrelated events?
They can, and it's a tactic often used to try to reduce the severity of the charges. The goal is to basically disconnect the theft from the assault, treating them as two distinct incidents.
So let's say someone shoplifts from a store and then gets into a fight with security in the parking lot. Could they claim that the fight had nothing to do with the shoplifting?
They could try. The defense would try to portray the fight as a separate event, maybe triggered by a personal dispute or something totally unrelated. The aim is to convince the court that the shoplifting and the assault weren't part of the same criminal act.
This is all making a lot more sense now. It's amazing how many layers there are to these cases. But we've also got these documents about offenses related to robbery, things like extortion, kidnapping, unlawful confinement. Are there any interesting connections or overlaps there?
Definitely some common threads running through them. They all involve some degree of threat, violence, or unlawful restraint.
So it's like a whole web of interconnected crimes, each with its own unique features, but all ultimately about taking away someone's freedom or property.
Exactly. And understanding those nuances is crucial for navigating the legal system.
Well, you've definitely shed some light on those nuances today. But now I'm even more curious about these related offenses. They sound like they come with their own set of fascinating legal complexities.
They certainly do. Each one presents unique challenges, and we could easily spend hours dissecting them.
Maybe we should. Sounds like we have a lot more to unpack. But for now, let's focus on how these different offenses are classified and how those classifications impact the potential consequences.
That's where things get really serious. The distinction between indictable and summary conviction offenses is key to understanding the severity of these crimes.
Okay, I'm ready to dive into that. Let's get started.
So let's start with robbery itself. It's considered a strictly indictable offense in Canada.
Okay, strictly indictable. What does that actually mean for someone facing this charge? What are we talking about here?
We're talking serious consequences. Section 344 of the Criminal Code lays out the penalties. And it's pretty straightforward. A robbery conviction could land you in prison for life.
Life in prison. Wow. That's intense. So it doesn't really matter what was stolen or how badly the victim was hurt.
Not in terms of that maximum penalty, no. The law sees all robbery as inherently serious. But there are definitely some aggravating factors that can make the sentence even harsher. Like, if a firearm is used during the robbery, the minimum sentence jumps up significantly.
Makes sense. A gun definitely adds a whole other level of danger.
For sure. And it gets even more nuanced than that. The criminal code actually distinguishes between different types of firearms, restricted, prohibited, and regular. Using a restricted or prohibited firearm comes with the most severe penalties.
So if someone robs a store with, say, an illegal handgun, they're looking at a much tougher sentence than if they'd used, like, a hunting rifle.
Exactly. The law takes into account the type of weapon and how dangerous it is. And here's another thing that can really impact the outcome of a robbery case. Organized crime.
Organized crime. Figured that would come up eventually.
If a robbery is connected to a criminal organization, the minimum sentences get even longer. It's the law's way of recognizing the increased danger posed by organized crime and trying to deter people from getting involved.
Okay, so to recap, robbery is a strictly indictable offense. which means it's treated very seriously by the courts. We're talking potential life sentence, and even longer if aggravating factors are involved, like using a firearm or ties to organized crime. Now, what about those other offenses we've been discussing? Extortion, kidnapping, hostage-taking, how do they stack up?
Well, they're all in the same category as robbery strictly indictable offenses. And just like robbery, they carry a maximum penalty of life imprisonment.
Wow, so the law really doesn't mess around when it comes to these types of crimes.
It doesn't. And it makes sense when you think about what they all involve. Some form of coercion, violence, taking away someone's freedom. These are serious violations.
Right, so the takeaway here is if a crime involves a serious violation of someone's safety or freedom, it's going to be treated as a major crime with potentially life-altering consequences.
Exactly. The law is there to protect individuals from harm and ensure a safe and just society.
But not all the offenses we've talked about are strictly indictable, are they? The documents you sent also mention things like unlawful confinement, disguise with intent, intimidation. Those seem a little less clear-cut.
You're right. Those are classified as dual offenses, which means they can be treated as either summary conviction offenses or indictable offenses.
Little offenses. Okay, that's a bit confusing. What does that mean practically? Like, how does that work in court?
Basically, it gives the Crown prosecutor some flexibility. They can choose to proceed summarily, that's less serious, lighter penalties, or they can go the indictment route, which makes it a more serious case with harsher punishments possible.
So it's like the Crown gets to decide how hard they want to come down on the accused.
In a way, yes, they consider a bunch of factors. The specifics of the offense, the level of harm to the victim, the accused's criminal history, what serves justice best.
Sounds like a lot of strategy goes into those decisions.
Hmm.
Okay, let's break down these dual offenses one by one. Let's start with unlawful confinement. If the Crown goes the indictment route, what are we looking at punishment-wise?
The maximum penalty for unlawful confinement is 10 years in prison. So, yeah, it's pretty serious.
10 years. Wow. Okay, what if they proceed summarily? What happens then?
The penalties are much less severe. We're talking fines, probation, or shorter jail time, usually under 2 years. Really depends on the situation and the judge.
So a pretty big difference depending on how the Crown decides to proceed. What about disguise with intent? That one sounds interesting. Maximum penalty if the Crown goes indictable.
10 years for that one, too. It's kind of fascinating, actually. Shows you how seriously the law takes the act of preparing to commit a crime, even if that crime never actually happens.
So even if someone is caught wearing a mask outside a bank, but they haven't actually robbed it, they could still be facing a decade behind bars.
That's right. It's about deterrence, sending a message. Even the intention to commit a crime can have serious consequences.
Interesting. Okay, let's wrap up these dual offenses with intimidation. What's the potential punishment there?
Intimidation as an indictable offense carries a maximum penalty of 5 years. Might not sound as bad as 10, but still shows you it's taken seriously. Using threats or violence to force someone to do something, that's a big no-no.
5 years is still a long time. The law is definitely drawing a line in the sand there.
It is. It's about protecting people's rights and freedoms, making sure they can make choices without fear.
Okay, I think we've done a pretty good job breaking down these different offenses and how they're classified and punished under Canadian law. It's amazing how much variation there is in the system.
It's true. The law is a complex system, always trying to balance justice with the fact that every case is different.
Speaking of different cases, we've talked a lot about the legal definitions, the classifications, the possible punishments. But I keep thinking about the human side of all this.
The why behind it all.
Exactly. What drives someone to commit these crimes? Robbery, extortion, kidnapping. What are their motivations? What circumstances lead them down that path?
It's a great question, and one I think we should explore more. We've covered the what and the how, but the why is just as important, maybe even more so.
I completely agree. It's easy to get lost in the legal technicalities, but these are real people, real lives. Understanding their stories is crucial.
Absolutely. Something to delve into in a future deep dive, perhaps.
I'd be up for that conversation. But for now, let's shift gears a bit and really dig into those defenses in robbery cases. We've touched on it, but I think it's worth spending more time unpacking those different strategies.
It's where things get really interesting, seeing how defense attorneys challenge these charges. It's fascinating.
All right, let's get into it. Okay, so we've talked about the different ways robbery can happen, the potential consequences, and even touched on those related offenses like extortion and kidnapping. But now let's dive into the really juicy stuff. The defense strategies. This is where things get strategic.
Absolutely. This is where we see those legal minds at work, analyzing every detail, searching for weaknesses, building a strong defense. It's fascinating.
So, based on what you sent over, it seems like you're especially interested in the defenses used in robbery cases, trying to figure out how strong a case might be, maybe exploring different legal angles. Smart move.
It's all about understanding the options. Every case is unique, so what works in one situation might not fly in another. It all boils down to the evidence and the legal
Right,
arguments.
the specifics matter. So let's get into some of those defense strategies. We talked about how most of them tend to focus on one of three things: the theft itself, the alleged assault, or the link between the two. Let's start with a theft. How might a defense attorney challenge that part of the crime?
One common approach is to argue that no theft actually took place. Sounds counterintuitive, maybe, but remember, the Crown has to prove beyond a reasonable doubt that the accused intentionally took something that didn't belong to them.
So if someone took something they genuinely believed was theirs, even if they were mistaken, that could be a valid defense.
Exactly. Think of it like this. Let's say someone takes a bike, convinced it was stolen from them years ago. Even if they're wrong about the bike's ownership, if they can show they truly believed it was theirs, that could weaken the theft element of the charge.
Makes sense. It's all about intent, right? If they didn't intend to take something that wasn't theirs, it's not really theft.
Right. And another strategy is to challenge the assault element. Robbery involves both theft and assault, so if the defense can successfully argue that there was no assault, well, that weakens the prosecution's case significantly.
So how do they do that? We've talked about provocation and consent. How do those come into play in a robbery case?
Imagine a scenario where, during a robbery, the accused claims the victim provoked them into a fight. If they can back that up with evidence, it could raise doubt about who was really the aggressor. Or, if they can show that any physical contact was actually consensual, that would challenge the assault element too.
It's all about shifting the narrative, right? Presenting a different version of what went down.
Exactly. Finding inconsistencies, poking holes, creating enough doubt to maybe secure an acquittal or at least a lesser charge.
Yeah, this is getting really interesting. It's like a legal chess match. Now, that connection between the theft and the assault, I'm still a bit fuzzy on how someone could argue those were two separate things.
It's a clever strategy, that's for sure. Picture this. Someone shoplifts from a store, right? Then, as they're running away, they get into a fight with a security guard outside. The defense might argue that the fight was totally unrelated to the shoplifting, maybe a personal dispute, a misunderstanding, something else entirely.
So they're trying to separate those two actions, break the chain of events, and say the theft and the assault weren't part of one continuous robbery.
Exactly. And if they can do that, they might be able to get the robbery charge reduced to separate charges of theft and assault, which could mean a much lighter sentence.
Wow, it's amazing how much strategy and nuance goes into defending these cases.
It really is. It's a complex area of law requiring a deep understanding and some creative thinking.
Okay, so we've covered a lot today. The different types of robbery, the potential consequences, those related offenses, and even the defense strategies used to challenge these charges. But there's one more thing I want to touch on. We focused a lot on the legal side, but what about the human element?
That's a crucial point. The law is there to provide justice, but it doesn't always capture the full human story. It's easy to get caught up in the legal jargon and procedures, but at the end of the day, we're dealing with real people, real lives.
Think about it. What drives someone to commit robbery, or extortion, or kidnapping? Is it always about greed or pure malice? Are there other things going on, psychological factors? And the victims, how do they cope with the impact of these crimes?
These are tough questions, and there are no easy answers. Each case is unique, and the motivations are complex. Sometimes it's desperation, sometimes a sense of entitlement, sometimes mental health issues or addiction play a role. And for the victims, the effects can be long-lasting, leading to trauma, fear, and a loss of trust.
It's a good reminder that the legal system, while important, is just one piece of the puzzle. We need to look at the root causes, provide support for both victims and offenders, and try to create a society where these things are less likely to happen in the first place.
Absolutely. It requires a multifaceted approach involving law enforcement, social services, mental health professionals, everyone working together. It's not just about punishment, it's about prevention and rehabilitation too.
Well, I think that gives our listener plenty to think about. We've explored the legal landscape, the defense strategies, and even touched on the human side of these crimes. Hopefully, this deep dive has shed some light on this complex and often challenging area of law.
It's been a pleasure joining you on this deep dive. These legal topics are endlessly fascinating.
Thanks for being here. And to our listeners, thank you for sending over your documents and trusting us to guide you through this deep dive. We hope you found it informative and thought-provoking. Until next time, stay curious, stay informed, and remember the world of law is full of surprises and insights just waiting to be discovered.